is the story of a married Hindu couple in Malaysia who were blessed with 3 children. On 11th of March 2009, the husband Padmanathan Analaki Krishnan converted to Islam and subsequently obtained the custody of the 3 children from the Sharia High Court. Apparently, when the custody order was given, the elder 2 children were with the wife, Indira Gandhi, but youngest child was with the husband. Later, in April 2009, Indira received certificates of conversion showing that the Registrar of Mualaf had registered all her children as Muslims. The wife then filed an application to the civil courts to quash the unilateral conversions of her children and obtain custody of them. Indira challenged the decision of Registrar of Mualaf on the grounds that first, the registrar had acted in breach of the procedure set out in Section 96 and 106 of the Administration of the Religion of Islam Para Enactment 2004, and second, the certificates issued were void. First, let's have a look at Section 96 and 106 of the Para Enactment. Section 96 provides that for a valid conversion of a person to Islam, the person must utter the affirmation of faith in Arabic by his or her own free will, and at the time of the utterance, the person must be aware of the meaning of the utterance. Furthermore, the person who is incapable of speech may utter the affirmation of faith by means of signs that convey the meaning specified in the utterance. Meanwhile, Section 106 stipulates that a person who is not a Muslim may convert to Islam if he is of mind and has attained the age of 18 years. If he has not attained the age of 18 years, his parents' consent in writing to his conversion is required. The High Court found that the requirements of conversion to the religion of Islam, as stated in Section 96 and 106 of the Administration of the Religion of Islam Para Enactment 2004, has not been properly complied with. Hence, it was ruled that the certificates were null and void and of no effect, and later ordered the certificate issued by the registrar to be quashed. The parties in grief, which comprise of Muhammad Ridwan Abdullah, who is the converted husband, the director of the Islamic Religious Affairs Department of Perak, the Registrar of Mualafs, the Perak government, the Ministry of Education, and the government of Malaysia, had subsequently appealed to the Court of Appeal, and it was held that the High Court had no power to question the decision of registrar or to consider the registrar's compliance with the statutory requirements of Section 96 and 106 of the Administration of the Religion of Islam Para Enactment 2004. The court was in the view that if a person had been registered in the Register of Mualafs, as stated in his certificate of the conversion, it is proven that the conversion process has been done to the satisfaction of the registrar. Thus, the decision of the High Court was set aside.
Unsatisfied with the decision by the Court of Appeal, Indira Gandhi later appealed to the Federal Court by submitting that Article 121 Clause 1A of the Federal Constitution did not overrule the general jurisdiction of the High Court or enhance the jurisdiction of the Sharia Court. However, the respondent argued that matters of Islamic law will fall under the Sharia Court jurisdiction pursuant to the 9th schedule of the Federal Constitution, and that, since the subject matter did not lie within the High Court jurisdiction, the High Court could not exercise its power to review the action of the Registrar of Mualaf. The Federal Court, in delivering the judgment, stipulated that Article 121 Clause 1A does not grant exclusive jurisdiction to Sharia Court in all matters of Islamic law, including those relating to judicial review. Article 121 Clause 1A does not remove the civil court jurisdiction to interpret the constitution or law even when the matter is related to Islamic law. Besides, the court explained that a child from a non-Muslim marriage must comply with the legal requirement in state law before the Registrar of Mualaf can register to conversion of Islam. In this case, Indira's children were not present before the registrar and did not alter the affirmation of faith as required under the Para enactment. It was concluded that the registrar had acted beyond his power as he had issued the certificate of conversion of Indira's children without complying with Section 96 and 106 of the Administration of the Religion of Islam, Para Enactment 2004. Furthermore, Article 12 Clause 4 of the Federal Constitution provides that a parent or guardian shall decide the religion of a person under the age of 18. Consent must be from both parents for the best interest of the child. Therefore, the Federal Court ruled that the unilateral conversion of Indira's children was unlawful. Although justice has sided with her, it has been 11 years since the last time Indira Gandhi saw her youngest daughter, Prasanna Diksha. The High Court in 2014 had issued an arrest warrant for Muhammad Ridwan Abdullah, but until September 2020, the Inspector General of Police said that the process to return Prasanna and Muhammad Ridwan was complicated and time-consuming as both were no longer in Malaysia at the moment. It was believed that until today, Muhammad Ridwan and Prasanna is living abroad and regularly relocating to avoid detection. Indira was frustrated with her current demise as she pointed out that the court has sided with her, but IGP sought to negotiate with her fugitive ex-husband for joint custody of Prasanna. Despite her unending challenges to reunite with her daughter, Indira was nominated as the U.S. Embassy in Malaysia nominee for the U.S. State Department International Women of Courage (IWOC) Award in 2018. The U.S. Embassy in Malaysia recognized her struggle for a number of years in court to achieve justice for her and her family to bring her daughter home. We hope that the authority in Malaysia may be able to reunite Indira back with Prasanna and give her the justice she deserves.